So I get a lot of questions about how do you use depositions in trial? And it's very important to understand the distinction between party depositions and non-party depositions, because you can use them totally differently, and some you can't use the same as the other. So a party deposition is a defendant who's a person, right? Or if it's a corporation as a defendant or as a plaintiff, then the managers and certain levels of designated PMKs are also designated as parties. When you have a party deposition under the evidence code, it is an exception to the hearsay rule as a party admission. So you can use that deposition or play that video for any purpose at any time. You don't even have to have the witness on the stand. You don't have to have it as impeachment. It's not required to be anything. You don't have to give the other side prior notice, other than enough notice for them to have any kind of objections, etc. A non-party witness, basically anyone who's not a plaintiff or a defendant or a person in the defendant company or the plaintiff company, a police officer, a witness, a little different if you're an expert witness, but a non-party, you cannot use their deposition unless it's for a couple of things. You have to ask questions, and if you have in their deposition impeachment, then you can use the deposition to impeach them. But you can't use a deposition of a non-party to basically reiterate that they said at depo something consistent with what they're saying in court, because it's not impeachment. Now, you can also use a deposition for either a party or a non-party to refresh their recollection if at the time of trial they don't remember something, but if looking at the deposition, will refresh their memory for them to tell the jury. But when you do that, you don't read the deposition. You literally go up to the witness and you show them the section, and they read it silently, and then you say, Your Honor, I would like to show the witness page so-and-so, whatever, for the purposes of refreshing their recollection. You take it up there and they read it, and then you ask the witness, does that refresh your recollection? If they say no, you move on. If they say yes, then you re-ask the question and they give the answer. But what's in the depo, if it's just to refresh the recollection, doesn't actually come into evidence and is not read. So again, the two big distinctions in using depositions at trial is if they're a party, you can use it for impeachment. You can use it just to play it. You don't have to have the witness. You can play their video or read their depo at any time and with multiple witnesses while you've got somebody else on the stand. Well, the defendant said in their depo X. If they're a non-party witness, you can't read a deposition unless it is impeachment. And you can also use a deposition to refresh someone's recollection, but you can't read it to the jury. It just has to come through the witness. Any other questions, please reach out in the bio or the video description.